The subcommittees will come to order, and good afternoon, everybody. The 2-year-old Syrian civil war has produced increasingly horrific human rights violations, including summary executions, torture, and rape. Most recently, both government and rebel forces have targeted medical and humanitarian aid personnel. Snipers, and I read this and I was sickened by it, are reportedly targeting pregnant women and children and actually passing around cigarettes when they kill an unborn child who was put into their sights. Since the civilian civil war began, more than 100,000 people have been killed and nearly 7 million people have been forced to leave their homes. By December of this year, it is estimated that neighboring countries such as Turkey, Lebanon, and Iraq could see as many as 3.5 million Syrian refugees. Those who have perpetrated human rights violations among the Syrian government, the rebels, and the foreign fighters on both sides of this conflict must be shown that their actions will have serious consequences. H-Con Res 51, introduced on September 9th, calls for the creation of an international tribunal that would be more flexible and more efficient than the International Criminal Court to ensure accountability for human rights violations committed by all sides and by more people. This hearing will examine the diplomatic, political, and legal and logistical issues necessary for the establishment of such a court. Today's hearing will examine controversial issues such as sovereignty, the ICC versus ad hoc regional tribunals, and the sponsorship of such a tribunal. Perhaps the most famous war crimes tribunals were the Nuremberg and Tokyo trials, the post-World War II trials of Axis military officers and government functionaries responsible for almost unimaginable crimes against humanity. The Cold War rivalry between the U.S. and the former Soviet Union prevented the international cooperation necessary for war crimes tribunals to be convened by the UN. After the end of the international political conflict, there have been 3 particularly notable international tribunals to hold accountable those guilty of genocide or crimes against humanity in the former Yugoslavia, in Rwanda, and in Sierra Leone. Each of these tribunals have achieved a level of success that has escaped the International Criminal Court. The Yugoslavia Tribunal, for example, has won 69 convictions, the Rwanda Tribunal 47, and the Sierra Leone Tribunal has won 16 convictions. Meanwhile, the ICC, costing about $140 million annually, has thus far seen only 1 conviction. The ICC process is distant and has no local ownership of its justice process. It is less flexible than an ad hoc tribunal, which can be designed to fit the situation. The ICC requires a referral. In the case of the President and Deputy President of Kenya, it was Kenya itself that facilitated the referral. This is highly unlikely in the case of Syria. Russia and the UN Security Council would likely oppose any referral of the Syrian matter to the ICC, but might be convinced to support an ad hoc proceeding that focuses on war crimes by the government and by the rebels, one that allows the plea bargaining for witnesses and other legal negotiations to enable such a court to successfully punish at least some of the direct perpetrators of increasingly horrific crimes. And Syria, like the United States, never ratified the Rome Statute that created the ICC, which does raise legitimate concerns about sovereignty, with implications for our country with this panel, which will also be addressed today. There are issues that must be addressed for any Syria War Crimes Tribunal to be created and to operate successfully. There must be sustained international will for it to happen in a meaningful way. An agreed-upon system of law must be the basis for proceedings. I remember when we were discussing the tribunal for the former Yugoslavia, sitting right here in this room, not only did I convene hearings on it, I actually passed a resolution that was passed on the Senate side by Alphonse D'Amato. I did it on the House side, because we were so concerned that important information was not being transferred to the chief prosecutor to allow a successful indictment and prosecution of Slobodan Milosevic and others. I remember also there was concerns about, there was people concerned, a number of very, very interested parties, that it was designed to fail because it was so grossly underfunded, particularly at its onset, so that the kind of work that needed to be done was not being done. An agreed-upon structure, a funding mechanism, and a location for the proceedings must also be found. There must be a determination on which and how many targets of justice will be pursued. A timetable and time span of such a tribunal must be devised as well. And there are even more issues that must be settled, and if there's a will, they will be. David Crane, one of today's witnesses, has suggested 5 potential mechanisms for a Syrian war crimes tribunal. 1, an ad hoc court created by the UN. 2nd, a regional court authorized by treaty with a regional body. An internationalized domestic court, a domestic court comprised by Syrian nationals within a Syrian justice system. And of course, the 5th would be the ICC itself. Each of these first 4 models have some benefits, some more than others. The ICC can be ruled out, and a domestic court in the near future seems highly unlikely. However, we are not here today to decide which of these models will be chosen. Rather, our objective in this hearing is to promote the concept of a Syrian war crimes tribunal, whatever form it eventually takes. Again, those who are now even perpetuating crimes against humanity must be told that their crimes will not continue with impunity. Syria has been called the world's worst humanitarian crisis. According to the World Health Organization, an epidemic of polio has broken out in northern Syria because of declining vaccination rates. One might reasonably also consider it the worst human rights crisis in the world today. Therefore, the international community owes it to the people of Syria and their neighbors to do all that we can to bring a halt to these actions while creating an accountability effort. We have assembled a highly distinguished panel to discuss the pros and cons of creating and sustaining a Syrian war crimes tribunal. This is not an academic exercise. We must understand the difficulties of making accountability for war crimes in Syria a reality, and we must do it now. Therefore, we must understand the challenges involved so that we can meet and overcome them and give hope to the terrorized people of Syria. Their suffering must end, and the beginning of that end could come through the results of today's proceedings. I'd like to yield to my friend and colleague, Ms. Bass, for any opening comments.
Thank you, Chairman Smith and Ros-Lehtinen. Thank you for your leadership in holding today's joint committee hearing. As members of this committee are well aware, the Syrian crisis is in its 3rd year, and unless something is done to end atrocities, it may well continue. While I'm pleased with news reports that indicate the Syrian government has cooperated with international officials toward dismantling and disposing of illegal chemical weapons, the human tragedy remains deeply disturbing and unanswered. The Congressional Research Service reports that over 100,000 Syrians have been killed just since March 2011. Globally, estimates indicate that some 2 million Syrians have fled the country and more than 4 million people have been internally displaced. But it is the indiscriminate slaughter of people, particularly women and children, that is and should move all nations to act to end this tragedy and hold those who have committed crimes against humanity and human rights violations accountable. We're all aware of the airstrikes that have killed thousands, and we know of the attacks by opposition forces that have also killed innocent civilians, fracturing families and leaving mothers and fathers without their children and children without their parents. These attacks, whether by the Syrian government or opposition forces, are without question serious human rights violations and stand in stark contrast to international laws and norms created to preserve life and peace. The international community is unfortunately all too familiar with establishing mechanisms to address war crimes and crimes against humanity, and yet we find ourselves here once again debating what course should be taken to address the evils of war. We've seen the establishment of international criminal tribunals for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, the Khmer Rouge Tribunal, and of course the ICC. Each of these and other mechanisms were created to address the tragic and deplorable actions of those who cared so little for human life and dignity. While this committee can debate whether a new tribunal for Syria should be established or whether the current mechanisms that exist are sufficient, I am reminded of the tireless effort of human rights defenders around the world who often put themselves in grave danger in order to both gather evidence and document human rights violations. One such effort is being conducted by the Syria Justice and Accountability Center, or SJAC. The SJAC is an independent organization that collects, preserves and analyzes information on alleged human rights violations and other relevant data to inform and contribute to the transitional justice process for Syria. The SJAC is currently reviewing nearly 300,000 videos and 200,000 documents in an effort to track and prepare files for the day when justice can be served. The SJAC receives support from 40 nations. It is a Syrian-led initiative, and the aim of the center is to document violations of human rights and humanitarian law in Syria in order to support future transitional justice processes that might be adopted by the Syrian people themselves. We all know the Syrian crisis is not merely a crisis that impacts Syrian people. It is an international crisis that requires global attention. It's my hope that today's hearing and the hearing that will undoubtedly follow will cast a light on policies that will wisely and swiftly end this crisis and heal the lives of those caught in the balance. Thank you, and I look forward to today's testimony.
I thank my friend. I'd like to now yield to the co-chair of this hearing today, but also the former chairman of the full committee who served with great distinction and now chairs the the Middle East and North Africa Subcommittee Chairwoman Ileana Ros-Lehtinen.
Well, thank you very much, Chairman Smith. Thank you for your leadership on this important issue, and thank you to my good friend, Ranking Member Bass, for jointly holding this hearing today. Now in its third year, the Syrian conflict has caused unspeakable damage to the people of Syria. It has placed a heavy burden on Syria's neighbors, like our ally Jordan, which has taken in over 600,000 refugees, even though it strains the kingdom's security and economic situation. Refugees have also gone to Lebanon, to Turkey, to Iraq, to Egypt. It has seriously jeopardized the safety and of our friend and ally, the Democratic Jewish State of Israel. This humanitarian tragedy has resulted in the deaths of at least 100,000 over the last 2 years and has forced more than 2.2 million Syrians, around 10% of the population of the country, to flee to neighboring countries, and over 5 million Syrians are classified as internally displaced persons, IDPs. The situation remains bleak and continues to get only worse with each passing day. Disease outbreaks are rampant in Syria, with polio, measles, typhoid, and hepatitis A all on the rise. The children are malnourished, they are not getting an education, and they can be easily radicalized by those extremists who prey upon those most susceptible. Anti-American attitudes are being spread by extremists as refugee camps become breeding grounds for terrorist groups to spread their radical ideologies and recruit young people to join their ranks. The harsh living conditions in these camps also leave women vulnerable to exploitation by sex traffickers, where girls are forced into short-term marriages for money to help support their families. Christian communities in Syria have taken a huge toll in this conflict, as Christians are being targeted for kidnapping, torture, and murder by radical Islamists who hate them just for being Christians, and many of their homes, churches, and neighborhoods have been destroyed. And there is no end in sight. Yet this administration, whose foreign policy has been plagued with inconsistencies and paralyzed by indecision, has not moved to take decisive action, and not just in Syria, but across the region, in Egypt, in Iran, and elsewhere. Time and time again, the administration takes half measures or no measures, and its indecision has eroded our credibility in the region, has greatly reduced our leverage over some of these nations, and it has severely strained our relations with many of our allies. And it has done so all for what? Assad still remains in power, even though he has used chemical weapons to murder hundreds of his people. Extremists still roam the country, targeting those who do not share their strict view of Islam, and yet the administration thinks it would be a good idea to provide arms to those people who hate us as much as they do Assad. So we have sacrificed our standing in the region for the possibility of eliminating chemical weapons, but we still leave the ruthless dictator in power. And no one has been made accountable, not for the chemical weapons use, not for the deaths of over 100,000 Syrians, not for the targeted attacks on Christians or other religious and ethnic minority groups. President Obama took quite some time to get around to the idea that Assad must be removed from office. But now, after the chemical weapons use and the U.S.-Russian framework agreement, it seems that the administration's position is now that Assad can stay as long as he plays nice on chemical weapons. We took a backseat to Moscow when it has been Russia who has been backing Assad and giving him the supplies and the weapons he needs to continue to murder his own people. And it is the same Russia that blocked every effort we tried to make at the UN to hold Assad accountable for his action and stonewalls our attempts to prevent Iran from becoming nuclear capable. And now we expect Russia to take the lead and really hold Assad's feet to the fire over his transgressions. What kind of message does this say to the people of Syria who are being slaughtered and forced to flee, or to our enemies, and most importantly, to our allies? Assad must be held accountable, Mr. Chairman. I agree with you. And when it comes to the Syrian War Crimes Tribunal, we must ensure that those left behind those behind these atrocities are held accountable without placing our brave men and women in jeopardy and out of our jurisdiction. I thank the Chairman and Ms. Bass for holding this hearing. Thank you, sir.
Madam Chair, thank you very much for your very powerful statement. Mr. Kennedy.
Thank you, Mr. Chairman. I just want to, I will be brief. I just want to thank the witnesses for being here on such an important topic as we try to learn about the best ways and some of the ways that we can try to make sure that we hold those accountable for some of the atrocities that we have been seeing and witnessing over the past several months and years. And I want to thank the Chair and Ranking Member for putting together an important hearing and giving us an opportunity to learn from some experts about the best way to do that. So thank you very much. I look forward to your testimony.
Thank you. Chairman Shabbat.
Thank you. I just want to thank Chairman Smith and Chairman Ros-Lehtinen, as well as the Ranking Member, for calling this hearing today, and I want to thank our panel of distinguished witnesses for taking the time to join us as well. Violence in Syria has been spiraling out of control, and I think most of my colleagues would agree that some measure should be taken to hold the responsible parties accountable for the atrocities committed throughout this brutal conflict. I sincerely hope that our discussion here today will offer some potential solutions for bringing to justice those guilty of the ongoing war crimes in Syria. And I yield back.
Thank you very much, Mr. Chairman. Ms. Frankel.
Thank you, Mr. Chair. I just thank you all for being here. We'll listen with interest. I think everybody agrees that what is happening in Syria is tragic. We'd like to have the wrongdoers, it seems like there are many of them, held accountable, but the big question is, realistically, what can we do? So I will be listening with an open mind. Thank you.
Mr. Meadows.
Thank you, Mr. Chairman, and thank you, Madam Chairman, for holding this joint hearing, and Ranking Member Bass. In the interest of time, what I'm going to do is just submit my opening statement for the record. I'll yield back.
Any other member would like to be heard? If not, I'd like to now introduce our very, very distinguished panelists, beginning with the Honorable Jeremy Rapkin. Dr. Rapkin is a professor of law at George Mason University School of Law. Before joining the faculty in June of 2007, he was for more than 2 decades a professor in the Department of Government at Cornell. Professor Rapkin serves on the board of directors of the U.S. Institute of Peace. He also serves on the board of academic advisors of the American Enterprise Institute and on the board of directors of the Center for Individual Rights, a public interest law firm here in D.C. He has published several books, and his articles have appeared in major law reviews, political science journals, and a range of magazines and newspapers. And without objection, a full bio of all of our witnesses will be made a part of the record. We will then hear from Mr. David Grain, former chief prosecutor for the United Nations Special Court for Sierra Leone. Mr. Crane was appointed a professor of practice at Syracuse University College of Law in the summer of 2006. He was the founding chief prosecutor of the Special Court for Sierra Leone and International War Crimes Tribunal. Professor Crane's mandate was to prosecute those who bore the greatest responsibility for war crimes, crimes against humanity, and other serious violations of international human rights committed during the civil war in Sierra Leone in the 1990s. He served for more than 30 years in the federal government and held numerous key managerial positions during his 3 decades of public service. And again, many of those prosecutions that put some of the worst perpetrators of crimes against humanity is a direct result of the work that he did as chief prosecutor. We'll hear from Dr. Alan White, former chief investigator, UN Special Court for Sierra Leone. Dr. White is currently professor of AW Associates, a global consultancy specializing in international criminal investigations and training involving crimes against humanity, war crimes, human rights, fraud, and anti-corruption. As the founding chief investigator of the UN-backed Special Court for Sierra Leone, he directed all international criminal investigations involving war crimes. He is a 30-year federal law enforcement veteran, where he last served as in the Department of Defense and directed global operations in all criminal investigations involving terrorism, cyber crimes, bribery, corruption, kickbacks, major fraud, and other major crimes. We'll then hear from Mr. Stephen Rademacher from the Podesta, a wide-ranging experience working on national security issues in the White House, the State Department, the U.S. Senate, and House of Representatives, and once sat right here as one of the top counsels for this committee. And he currently advises the Podesta Group's international clients, serving as an Assistant Secretary of State from 2002 through 2006. He headed at various times 3 bureaus of the State Department, including the Bureau of Arms Control, the Bureau of International Security and Non-Proliferation. He also directed the Proliferation Security Initiative, as well as non-proliferation policy towards Iran and North Korea, and led strategic dialogues with Russia, China, India, and Pakistan. We'll then hear from Mr. Richard Dicker, who's Director of Human Rights Watch's International Justice Program since it was founded in 2001, and has worked at Human Rights Watch since 1991. He started working on international justice issues when Human Rights Watch attempted to bring a case before the International Court of Justice, charging the government of Iraq with genocide against the Kurds. Mr. Dicker led the Human Rights Watch multi-year campaign to establish the International Criminal Court and has spent the past few years leading advocacy efforts urging the creation of effective accountability mechanisms. He monitored the Slobodan Milosevic trial in The Hague and made many trips to Iraq before and at the start of Saddam Hussein's trial. If we could go first to you, Professor Rapkin, and then each of our witnesses.
Well, I'm not sure why I was chosen to open this discussion. Maybe it was to lower expectations. I want to start by saying, Congresswoman Ros-Lehtinen, I agree with you. It's very disturbing that the Obama administration just seems to be floundering and doesn't seem to have a serious policy, and we do really seem to be forfeiting support in that region. However, that is not going to be fixed by a tribunal. So we should all understand that, right? This is at best a contribution and probably a somewhat marginal contribution. We started the modern era of international trials with the International Criminal Tribunal for the former Yugoslavia. And that was in 1993 when a lot of people were saying we need to intervene before the situation in the Balkans gets even more out of hand. And at that time, the Clinton administration said, well, we don't want to send troops. We don't actually want to be involved in bombing. Let's send lawyers. And that was not a particularly effective response. And the first thing I want to say is, let's all be cautious about this. Sending lawyers is not going to fix the situation in Syria. The next thing I want to say is if you set up an international tribunal, even an ad hoc international tribunal, our experience, Sierra Leone's a little different because it was based there and had involvement from people there, but the tribunals for Rwanda and the former Yugoslavia, I don't think they were very well received in the countries that they were supposed to help. And the people on those tribunals, both of which started in The Hague, the Rwanda one later shifted to Tanzania, but they got organized in The Hague. You start a tribunal in The Hague, and you take as your constituency not the country that you are actually supposed to be helping, but the community of international lawyers, because you're in the headquarters of international lawyers, The Hague. And so they did a lot of things which didn't impress people in Rwanda or in Yugoslavia, but made lawyers think, well, yeah, that's pretty good, that's interesting. I think the particular thing they did, which everybody feels is very regrettable, is they were excruciatingly slow. They went on and on and on. In the first 5 years, the Rwanda tribunal didn't have a single conviction. because they were getting organized. And this is after the murder of nearly 1 million people, right? And if you compare that to Nuremberg, within 1 year, we started the proceedings, and then the people who had to be hanged were hanged. We were just incredibly slow. I say we, the International Tribunal was. And when challenged about this, they said, well, it's really important to show that we have followed international standards of due process. Why was that really important? And I think it's because they took as their constituency, the people they were trying to impress, international lawyers. That's, I think, a very bad path to go down. If what you want to do is make a contribution to Syria, we got to focus on Syria and not what people think in The Hague. There's a very fine testimony by Michael Newton. I understand he wasn't able to make it today, but I just want to commend, he had experience advising the Iraqi tribunal that tried Saddam Hussein. And the main point he makes there, one of the main points he makes in his testimony, which is, I think, absolutely central, is you have to understand this as not so much a legal process, but the legal application of a political process. And the political process cannot just be determined by outsiders. There needs to be a lot of negotiation with people in Syria before we get this going. I think it is really out of the question to launch a tribunal while Assad is still in power. And even if within the next year or so, I hope he is succeeded by something else, we're going to have a lot of difficulties working out how this should be organized. And the focus should be what they will support and what will make them feel that this is justice. Let me just conclude with a last point. If peace does come to Syria, there is going to be a tremendous amount of bitterness and hatred directed at foreign fighters, because a lot of the worst atrocities are by people who came in from outside. We should all bear that in mind. Are they going to think, well, the foreign fighters were horrible, but the foreign lawyers, they're really great. They're our friends. If we say, no, they're lawyers from the good countries. Why are they the good countries? They're the countries that stood on the sidelines while they were all being massacred. I think we shouldn't start with the assumption that they're really eager for American or Western European assistance. I think there is assistance that we can give to them. But let's not start from the assumption that we mean well, therefore they're happy to have us. So I would suggest this. Before we get to a tribunal, we really need to gather evidence. I think we have a model that's worth thinking about from Lebanon, which is this independent investigative commission that they had starting in 2005 to investigate the assassination of Prime Minister Hariri. That experienced a lot of frustration, but it did gather a lot of evidence, and afterwards the Security Council was persuaded to establish a tribunal. That is maybe a model here, some kind of investigative commission which perhaps can work with the Syrian Accountability and Justice Commission, but gather more evidence, and then we can see what kind of tribunal that can be handed off to. Thank you.
Professor Rapkin, thank you very much for your testimony. I look forward to asking some questions when we get to it. We will take a very brief time off because there are 3 votes on the floor of the House. I would just, and we'll go to Mr. Crane next. I will have a number of questions to ask you because, and I just want this on the record because I hope members will come back. Sending lawyers wasn't the only thing we did with Yugoslavia. And as I said in my opening, and we'll get into it a little bit later, but part of the problem was many of us thought it was designed to fail because it was not being adequately resourced. And I was the one who introduced, along with Steny Hoyer, he was the chief co-sponsor of my bill, to lift the arms embargo because it was a one-sided fight, Milosevic versus 2 countries at least. Slovenia set them back, but certainly Croatia and the Bosnians had no way of defending themselves. So what we're trying to do here is a lessons learned, and I agree with you fully. It was too slow, and I felt there was a disingenuous effort by some to do a Yugoslav war crimes tribunal that was more of a showcase rather than a workhorse. And that's what we hope to learn from. But I do appreciate your testimony. If you want to respond briefly, then we
just one thing. Later on, we did what we had to do. Later on, we had real military intervention. At the beginning, though, I think this illustrates the moral hazard of international legal process, which is people feel they're doing something when they're not doing something. And I think in 1993, the Clinton administration didn't really want to do anything. And so they said, oh, yeah, let's have a legal process, right? And that's not by itself serious.
Thank you. We stand in short recess, and I apologize to our witnesses. I do hope the members will come back. The hearing of the subcommittees will resume. And again, I apologize to our witnesses and all assembled for the delays. I'd like to now recognize Mr. David Crane.
Well, thank you, Mr. Chairman. It's indeed an honor to be here this afternoon, and I do want to say for the record that I have submitted my remarks to you and the members of this panel, along with two appendices, which I believe you do have, one on the Syrian Accountability Project, an information PowerPoint, as well as the Chautauqua Blueprint, which is also a methodology by which we can create a court. And so I would humbly ask that this be submitted into the record.
Without objection, your statement and those of all of our distinguished witnesses and appendices to it will be made a part of the record. And I know normally 5 minutes is what people are allotted. Please feel free to use whatever time you feel necessary, and I say that to all of our witnesses.
Well, we thank you for your time, sir. I do want to note before I continue is that you and I go way back, along with a couple of members of this panel. Once again, sadly, we are back considering justice for another country that is being destroyed by another head of state. You were, in your leadership, along with the Chairman Royce and others, a bipartisan issue on both sides of the aisle. We do appreciate the support that you gave the Special Court for Sierra Leone and the work that myself and Dr. White were doing in trying to seek some justice for the victims of the atrocities in Sierra Leone. So I commend you, sir, for that continued leadership when we move into Syria. I'm going to address two items for you that are in my remarks, one of which is what you wanted me to talk about, and that certainly is the 5 possible justice mechanisms related to Syria. But I also want to talk a little bit about the Syrian Accountability Project and the Chautauqua Blueprint, just to highlight that there is an international effort working all across the board, to include our Syrian colleagues, to have in place a cornerstone mechanism by which a regional, local, or international prosecutor can start building a trial-ready case. And the reason why we're doing it such is we've already done it once before, and that is the takedown of President Charles Taylor of Liberia. We've taken the lessons learned there, and we have modified them and are developing this package called the Syrian Accountability Project. But first, let's go to the questions that you are most interested in first, Mr. Chairman, and that is the 5 possibilities of a justice mechanism in Syria. And I don't have them in order. I'm just listing them as the 5 possible mechanisms. The first is the International Criminal Court. Why the International Criminal Court? Because it is the permanent criminal court that possibly would have both subject matter and in personam jurisdiction over potential perpetrators of the atrocities in Syria. It is the world's only permanent international court, and it certainly is one of the viable mechanisms that the international community may consider in seeking justice for the people of Syria. A second option is an ad hoc court created by the United Nations. We've had 2 ad hoc courts. They are continuing their work now. It's been a stop-start process, but the ad hoc tribunals are moving forward and finishing their work, and there has been justice for the people of Rwanda as well as Yugoslavia. However, I must caution the chairman and members who are present that an ad hoc tribunal practically and frankly is a political non-starter. It's too expensive, and their reputation of being too long and too nimble to create a justice mechanism probably would not get very far as an option before the Security Council, because it would be the Security Council itself under Chapter 7 of the UN Charter that would have to agree to that, and I don't think that would happen. But I think to be open and in general, that still is an option. And of course, certainly we don't have any idea how this is going to play out over time. A third option would be a regional court, something very much like the International Hybrid Tribunal in Sierra Leone. And that model, of course, certainly has proven in general to have been a good model for that particular region of the world. I'm not saying that it would be for Syria, but again, it is another one of those options which we might want to consider as far as justice. A fourth option is an internationalized domestic court. We would have a chamber within the Syrian justice system, but it would be backed by and supported by the international community. And we've done that before. We have one that's very similar in Cambodia and what have you, but certainly working well in the Balkans, where we have international experts and practitioners assisting the Syrians or whoever country that is trying these cases, actually assisting them and helping them in their work. A fifth and final option would be a domestic court, a pure domestic court. In consideration of all of these, and having worked with the Syrian leadership and the Syrians, talking to Syrians, working with Syrians over the past 2+ years, this is starting to evolve into the preferred system. You know, what's wrong with Syrians trying Syrians for violations of Syrian law? And that is starting to become a more specific option for both this House and this committee to be thinking about, but also the international community, which leads me to my final part to my remarks, Mr. Chairman, and that is, how do we do that? In other words, we have these 5 mechanisms. Some of them have their challenges, and some of them are viable options. For 2.5 years, and we've been working with the Syrians, the international community, as well as non-governmental organizations, putting together a cornerstone package called the Syrian Accountability Project and the Chautauqua Blueprint, where we have mapped the conflict. We have developed a crime-based matrix of all of the major incidents that have taken place in this tragedy on both sides, on all sides, I should say, because again, it used to be both sides, and now that civil war has grown to where we have all kinds of actors. But this is a neutral effort, ensuring that we are accounting for all of the violations of international as well as Syrian law. We also have a mapping exercise, a unit mapping exercise. We have a team looking at crimes against women and children, as well as developing sample indictments so that a future prosecutor, be they domestic, regional, or international, will have a sample of what an indictment would look like. We've done this in West Africa, so that this has already the true test of time and practice, and all of this work is put together by some of the best and brightest at the international level, along with our Syrian colleagues, working hand in hand. At this point, what I'll do, Mr. Chairman, is I will just leave these remarks with this, and I look forward to any questions that you might have. And again, thank you for this opportunity.
It's great. Thank you so very much for your testimony. Dr. White.
Yes, sir. Chairman Smith, I'm honored and pleased to be able to testify before this committee on such a significant issue. I'm profoundly aware of the chairman's outstanding global leadership on the protection of human rights. I've experienced the chairman's support firsthand while serving as the chief of investigations for the United Nations-backed Special Court for Sierra Leone. In large part, the court's success in bringing some of the world's most notorious war criminals to justice, such as former Liberian President Charles Taylor, would not have been possible without your support and other members of Congress. Former President Taylor's involvement and support of the rebels who committed unspeakable war crimes and crimes against humanity impacted over 1.2 million victims in Sierra Leone and Liberia. Today, we're faced with a similar crisis in Syria as we experienced in Sierra Leone. We have another brutal dictator who's embroiled in civil war and engaged in wide-scale and systematic killings of innocent human beings with impunity. It is alleged President Assad has taken evil to the next level by employing the use of chemical weapons, killing thousands of defenseless, innocent women and children. Unfortunately, he's protected by a staunchest ally, Russia, which will undoubtedly block any formal referral from the United Nations Security Council to the International Criminal Court, allowing Assad to escape accountability with no justice for the victims. Most would agree an immediate alternative needs to be aggressively pursued. To ensure Assad and other perpetrators committing war crimes and crimes against humanity within Syria are held accountable and brought to justice, there must be an independent criminal court created to achieve justice. The establishment of a Syria War Crime Tribunal proposed in your congressional resolution is a legitimate and a viable solution. Further, in my judgment, the tribunal must be created immediately with the full support of the U.S. government and the international community. A Syrian War Crimes Tribunal could be established as an international hybrid tribunal with international authorities specifically mandated to investigate and prosecute those who bear the greatest responsibility for the commission of war crimes, crimes against humanity, and genocide. The Syrian War Crimes Tribunal could be backed by the United Nations, similar to the Special Court for Sierra Leone. It would be unwise and dangerous to establish the main tribunal in Syria while the country is engaged in a civil war. However, to expedite operation and minimize costs, the tribunal could be established in The Hague utilizing the current office space of the Special Tribunal for Lebanon with a regional office set up in a neighboring country to Syria. For example, Turkey would be an example, and Jordan. As mentioned previously, it is imperative that the tribunal be accountable to the victims and geographically located nearby. We now have years of experience to draw upon, and it is important we benefit from such experience, ensuring this tribunal is set up correctly, staffed properly, and financed definitively. It is my experience that most of the evidence used by prosecutors in international criminal court will be witness testimony. Maintaining trusted and close professional relationship is essential in making sure witnesses will be available and willing to testify when necessary. Unfortunately, this has been a major problem plaguing the International Criminal Court. Consequently, it will be absolutely crucial the investigators develop a trusted relationship at the onset to secure the best evidence and witness testimony. I know from my own experience that our physical presence in the region greatly contributed to our success in effectively gathering witness testimony. Being able to access witnesses and informants regularly unequivocally contributed to the success of the special court's prosecutions. The trusted relationship between our witnesses provided them with the necessary confidence to be able to provide courageous testimony on the world stage. Undoubtedly, the strong witness testimony was the bulk of our evidence, and contributed significantly to the successful prosecution of all cases. All of our convictions and sentences were upheld by the appeals chamber, which is a testament to the strong evidence presented in court. Although witness testimony is vital at any trial, it is especially true when prosecuting war crimes and crimes against humanity involving countries engaged in civil war or have emerged from civil war. All too often, physical and documentary evidence may have been destroyed during the war, so witness testimony is weighted heavily. Many of the witnesses will be victims, and a great deal of them will have been traumatized by the atrocities committed. For example, rape is often a tool of war, and many victims are reluctant to talk about what happened, particularly with strangers. War crimes investigations are routinely complex by their very nature and require a unique skill set to be able to conduct such investigations. It can take months for investigators to be able to develop a trusted relationship with a victim as well as witnesses. In many cases, witnesses will tell you stories if they had witnessed the crime personally, yet they're only passing on a story they heard from a family member or friend. This is particularly true in developing countries where tribes and clans living in villages are present and oral history is a tradition and common day practice. Thus, it will require an investigator who is skilled and experienced in conducting such investigations to be able to get the facts in a timely manner. Inexperienced investigators may take statements later deemed to be inaccurate because the witnesses did not actually observe any atrocity being committed, which can create unnecessary exculpatory issues. This is a major reason that investigators need to be located in the country or in the region for sheer logistical purposes. The investigators will be continuously conducting investigations, gathering facts and evidence. There will always be a need to conduct routine follow-up interviews on a regular basis. The key elements of proof in war crimes involve determining who was involved, was there a plan, was it wide-scale and systematic, military structure, chain of command, weapons involved, command responsibility, as well as identifying crime-based events. Conducting war crimes investigations is one of the most challenging, if not the most demanding type of investigation within the international criminal justice system, requiring the most highly skilled, competent, and talented criminal investigator. In my judgment, war crimes investigators must be experienced, criminal investigators. I would recommend 10 to 15 years experience, international. They be of high moral character, good judgment, well-educated, preferably a graduate degree, overseas experience, multilingual, excellent interpersonal skills, witness protection training, confidential informant training, and war crimes investigation training and/or experience. In my own experience, I met regularly with witnesses from Liberia and Ivory Coast, and during my tenure, both countries were engaged in civil war. Being situated nearby, my staff and I were able to meet with witnesses regularly, allowing us to develop a trusted relationship and execute our duties in a timely manner. For example, some witnesses had vital inside information, yet reticent to cooperate for fear of being identified and/or suspected of being a witness, which would undoubtedly pose an immediate danger to themselves or family members. Without a trusted relationship, it is extremely difficult, if not impossible, to convince witnesses in a war-torn region to come forward and become a witness unless they have complete trust and faith in you being able to provide for their safety and well-being. In those instances where witnesses' testimony was deemed vital for prosecution, you must be able to act immediately and decisively to demonstrate to the witness you can deliver on any assurances provided. Otherwise, investigators' credibility could be questioned and the operational effectiveness could be marginalized. Personally, I faced many exigent circumstances which required immediate action and a need to make command decisions. Being in a region and equipped with appropriate resources allowed me to deal with very challenging and dangerous matters. For example, one of my key witnesses was a former commanding general of the Liberian Armed Forces and was in Accra, Ghana, at a military medical facility receiving treatment for torture injuries inflicted by Chucky Taylor, the son of former President of Liberia, Charles Taylor, and is currently serving a 97-year sentence in U.S. prison for torturing my witness. The injuries were life-threatening and so severe the general's wife pleaded with Taylor to allow her husband to go to Ghana for treatment. In return, she offered herself and family as human collateral as a guarantee her husband would return. At the time, Taylor knew of the special court's existence and was very paranoid about anyone who could be a potential witness for the court leaving Liberia. While undergoing treatment in Ghana, I made contact with the general and received vital evidence Taylor and the rebel groups he supported in Sierra Leone. After vetting this information, a decision was made that he would be a major witness for prosecution and he needed to be relocated out of the region. Without an established witness protection program in place, I coordinated with the U.S. Department of State, sought their support to allow me to relocate the general and his family to the United States under the significant public benefit program. The U.S. was the only place I could relocate the general without fear of Charles Taylor being able to physically harm him or his family. With my operational contacts in the region, I was able to smuggle the wife and 8 children one by one to Accra, Ghana, and then on to the U.S. with the assistance of the U.S. Embassy and the International Migration Office. While this was ongoing, Taylor had sent some of his henchmen to Accra looking for the general, and once they learned he was no longer at the military hospital, they started canvassing the UN Liberian refugee camps in Accra as well as the entire city. The day we left Accra, they learned the whereabouts of the hotel where the general was staying, and we narrowly escaped their pursuit and went to the U.S. Embassy. Taylor's henchmen later showed up that same night at Accra International Airport and located us in the lounge while we were waiting to board. They attempted to breach security and were held at bay by the local airport authorities at the request of the U.S. Immigration and Naturalization Service agent who was armed and intervened while we boarded the aircraft. Meanwhile, the general's wife and children had been smuggled out of Liberia and were en route to Ghana. Due to the safety concerns for the general, we departed Ghana, flew to Amsterdam, and then on to the United States without incident. The family was later reunited 1 month later in the United States, safe and sound. The moral of this story is quite simple. If I had not been in the region and had contacts in place, I could not have been able to carry out this mission, and key witness could have been killed as well as his family. Currently, due to funding and staffing issues, the ICC has been unable to establish a full-time presence in many of the countries where they're actively engaged. As a result, they are experiencing serious witness issues involving their willingness to testify. The lack of a trusted relationship will have a major impact on any investigation and subsequent prosecution. This reinforces the need to establish a Syrian War Crimes Tribunal singularly focused and accountable to the victims of Syria and located closest to the people. Clearly, the witnesses associated with having any knowledge of war crimes being committed in Syria will undoubtedly have trust issues and an obvious reluctance to reporting information to anyone outside their family, their tribe, their clan, and/or their village. Consequently, developing a trusted relationship from the immediate onset, in my opinion, is a most crucial stage of any investigation, especially a war crimes investigation. Therefore, it is absolutely vital an investigator be regularly and personally engaged to nurture the trust with a witness. Otherwise, it will dissipate and have a major impact on the investigation and related prosecution. There isn't a robust witness management and witness protection program in place. The risk of a witness being killed, seriously injured, or physically threatened can occur, and if it does, it will undoubtedly have a chilling effect on any investigation and prosecution. The recent reports of ICC witnesses being killed, bribed, and threatened in regards to the ongoing trial of Kenya Deputy President as well as the impending trial of Kenya President highlight this very issue. We had over 600 witnesses at the special court, and although not all of them were deemed necessary to testify, many did and did so credibly, which accounted for the convictions attained. Although witness protection is the responsibility of the registrar, we felt strongly that the Office of the Prosecutor must have the capacity to carry out our mission. As a result, with the concurrence of the registrar, we created our own witness management unit to manage the witnesses of the Office of the Prosecutor. Based on our experience, the witness management and protection responsibility should rest with the Office of the Prosecutor and not the registrar. This must be taken into consideration when creating this tribunal. This is a major flaw and impacts investigations and prosecutions and certainly needs to be addressed if a Syrian war crimes tribunal is created. Witness testimony and vital information will dry up quickly if this very important phase of the criminal justice process is not implemented properly at the onset. Finally, I would like to address the accountability of a court to the victims and not merely to the international community. The ICC is also plagued with being viewed as a political instrument and not as a system of justice for victims. The recent investigations in the Ivory Coast, which has led to the prosecution of 3 members of the former government, including the former president, his wife, and former minister of sports, are being viewed as politically motivated and not balanced. Members of the current administration, including the current Speaker of the Parliament, have been documented by the United Nations and numerous human rights organizations as perpetrators of war crimes, yet no one has been prosecuted. It is important that all warring factions be aggressively investigated and prosecuted. Otherwise, the lack of balanced prosecution can undermine the peace and reconciliation process. It must be kept in mind the rule of law in Ivory Coast must be built on restorative and retributive justice, and the best way to achieve these goals is through local accountability. Towards that end, specifically and singularly mandated hybrids such as the Syrian War Crimes Tribunal with international authorities conducting its affairs under international law responsible to the victims is the best way forward. In conclusion, I believe the subcommittee's influence, support, and persistence can lead to the creation of a Syrian War Crimes Tribunal, which will ultimately lead to the prosecution of those involved committing war crimes and crimes against humanity. By bringing Charles Taylor, the former president of Liberia, to justice, we've demonstrated that no one is above the law. Now we all need the political will to support and do the just and noble thing. I want to thank you again, Mr. Chairman, and other distinguished members of Congress for allowing me the opportunity to share my thoughts and experiences in pursuit of a successful outcome for the victims of the Syrian civil war.
Dr. White, as we thank you. Thank you for that very extensive testimony and with that particular focus on the importance of the witness and all things related to. Thank you. Secretary Rademacher.
Thank you, Mr. Chairman. Thank you for having me here today, and Chairman Chabot, nice to see you as well. I have prepared remarks which I will not read to you. I will summarize a few of the key points and try and emphasize what I think are the most important issues before us. I'm here today to testify in support of your resolution, Chairman Smith, and I should say that fact would probably come as a surprise to many of my friends because I have a long record of criticizing war crimes tribunals of all stripes. And I spent the better part of my testimony offering additional criticisms of most of the war crimes tribunals that have gone before us. The only exception in my prepared testimony to that is the Sierra Leone Tribunal, or Special Court for Sierra Leone, where I actually have some positive things to say about the work that they've done. But I am critical of all of the others. But I come down differently on your proposal for a number of reasons, which I discuss toward the back end of my prepared statement. Maybe I'll summarize the reasons why I think, unlike the previous cases, the idea that you're proposing with respect to Syria is actually a good idea. First, I think a lot of times war crimes tribunals are established because the international community is frustrated and they can't think of anything else to do. And so, as Professor Rabkin, I thought, very eloquently stated in his testimony, in the absence of any sort of meaningful or serious policy, the UN decides to dispatch lawyers to address the problem, and then pats itself on the back, thinking that they've done something useful to address the problem. There was some dialogue between you and Professor Rabkin about the Yugoslavia Tribunal, and I personally am critical of the Yugoslavia Tribunal. Not because I think it's failed to bring war criminals to justice. I'm critical of it because I think as a historical matter, it was a very unfortunate compromise in 1993 between essentially the government of the United States and the governments in Europe, which had peacekeepers in Bosnia. And at that point, there was a fairly significant disagreement between the United States and the European governments about what to do in Bosnia. It was clear that the international efforts were failing, and the war was spiraling out of control. Casualties were increasing. The key issue at that time was the arms embargo on Bosnia, which you referred to. The United States was proposing, and members of Congress like yourself were offering legislation to end the arms embargo on Bosnia, which would have leveled the playing field. Europeans didn't want to do that. They had peacekeepers in Bosnia. And so the compromise that was worked out was, let's not do anything except send in lawyers. And my personal belief is that delayed by about 2.5 years serious measures that did eventually solve the conflict in Bosnia. And those serious measures were taken once your arms embargo legislation passed both the House and the Senate by veto-proof margins. That's when President Clinton decided, okay, I need a new policy, and he immediately commenced NATO bombardment of Serbian positions in Bosnia, and that led within a matter of months to the Dayton Peace Accords and the peace arrangement that's still in place in the Balkans to this day. My personal belief is that could have happened sooner, but for the delay that was brought about as a result of the decision to create a war crimes tribunal. And so I don't actually fault the tribunal for its work, but I do fault the decision to create it because I think that decision was taken to avoid taking harder decisions that governments didn't want to take at that time. But the point I make about your idea is I think in the case of Syria, and I hate to say this, I wish it weren't true, but I think unlike in Yugoslavia in 1993 and 1994, there are no other serious steps that the international community is going to be able to take. It's clear that the Security Council is not going to even impose sanctions on the Assad regime due to the position taken by the governments of Russia and China. I think the United States is not going to be prepared to act unilaterally as it threatened to do in the Balkans. The most recent diplomatic arrangement between the United States and Russia with respect to chemical weapons, I think guarantees that, in fact, U.S. policy is no longer even to overthrow or change the Assad regime. The Assad regime is now the diplomatic partner of the United States and Russia in trying to dispose of chemical weapons. And serious efforts to overthrow the government while we're working with it, I think, will not work. And I'm not sure the Obama administration has yet recognized that, but that's where U.S. policy is headed. And I think unlike in the Balkans in the 1990s when members of Congress like yourself were providing leadership on the issue, it's very clear from the debate that we had 2 months ago here in Congress about whether to authorize the use of force by President Obama in Syria, Congress is not going to be pushing for more forceful action in Syria. So in the absence of any prospect of more meaningful action by the international community, I think this is not a case like Yugoslavia where establishing a war crimes tribunal can serve as a pretext for not taking action that could otherwise be taken, because no other action is going to be taken, in my opinion. Second, I think this is a conflict where there are bad actors on all sides. That's increasingly apparent. And I think investigations by an ad hoc tribunal and eventual prosecutions could delegitimize not just the Assad government, but also those radical elements who, on the pretext of trying to free their country, are actually carrying out another more radical agenda in their country. And today, those groups are receiving outside assistance from some governments and individuals, and I think it might be harder for that assistance to continue in the face of international condemnation in the form of action by an ad hoc criminal tribunal against them. And then the third reason I can support your idea is because it's not the International Criminal Court that you're proposing. You're proposing to establish an ad hoc tribunal. And I want to speak particularly to this issue of the International Criminal Court because I do believe, as has already been pointed out, should the idea of acting against war criminals in Syria gain traction, we will certainly hear from the Europeans and others that the only possible way to do that is through the established international mechanism for handling these sorts of things, the International Criminal Court. And, Mr. Chairman, I want to state more emphatically with regard to this than anything else, the worst possible thing the international community could do in Syria is to deploy the International Criminal Court to go after war criminals in that country. We should do absolutely nothing before we do that because, well, actually, I will read one paragraph from my prepared remarks because I think this articulates my objection to the International Criminal Court's potential involvement more clearly than I can do it off the cuff. The ICC is an extremely blunt instrument. It is not an instrument of diplomacy, but rather an instrument of justice. By design, it exalts justice over all other objectives. This is the meaning and intention of Article 16 of the Rome Statute, which provides that once the court has taken up a case, it can never permanently be divested of jurisdiction to proceed with it. And not even the UN Security Council can defer the investigation or prosecution of the case for more than 1 year. Of course, Article 16 permits the Security Council to renew such deferrals once a year for so long as it may wish to do so. But the message of this provision to potential defendants is crystal clear. Once the ICC prosecutor has begun to pursue you, no power on earth can ever permanently rid you of him. So, my concern is that should the international community decide to turn on ICC jurisdiction with respect to Syria, the message to President Assad is he's either going to end up dead or in prison. Those are his two choices. And I think the international community needs to decide what it wants in Syria. If what it wants is justice, it wants to bring Assad to justice, it wants to bring his henchmen to justice, it wants to bring leaders of the al-Nusra rebel groups to justice, the ICC is the appropriate instrument. But if what we want to do is end the war, if we want to promote a democratic transition and try to bring to power a government led by someone else other than President Assad, sending in the ICC is the worst possible way to achieve that objective. Because if we want President Assad to give up power, you can imagine the conversation. I mean, the diplomats who speak to him are going to have to say, they're going to have to make it attractive to him to give up power. And it will not be attractive to him to say, give up power and then we're going to send you to prison. We have to offer him carrots if we want him to give up power. Threatening and promising him that he's going to prison will lead him to dig in. It will ensure that he never gives up power, that he ends up like Gaddafi. Why did Gaddafi stay in Libya and fight to the death? Unlike in Tunisia, where the dictator gave up and went into exile, unlike in Egypt, where Mubarak gave up and went into internal exile. In Libya, Gaddafi stayed and fought to the death. Now, maybe that had to do with the character of Gaddafi, but there was another element. The UN Security Council had conferred jurisdiction on the ICC to investigate war crimes in Libya, and it was crystal clear that Colonel Gaddafi was going to be the #1 defendant before the International Criminal Court. The international community said to Gaddafi, no, you don't have Mubarak's option. You can't retire peacefully. We're coming after you. And so he stayed and fought to the death. If that's what we want in Syria, we want this civil war to go on until somebody, corners Assad in a street and shoots him. The way to get to that objective is to bring in the International Criminal Court, because they will pursue him relentlessly. They will guarantee that he does not go peacefully. But I submit, though that may be from a purist point of view, that you want a pursuit of justice above all other objectives, that might be the right way to go. I think that there are more important values, more important objectives for the international community, most importantly, saving human lives of the Syrian people. And for that reason, I think we need to avoid solutions which will perpetuate the conflict. We need to look instead for solutions that will make it possible to expeditiously end the conflict. And I think an ad hoc tribunal, which is not subject to Article 16 of the Rome Statute, an ad hoc tribunal which could be turned off by Security Council action should there be a diplomatic settlement acceptable to all sides, that would make sense. That would be a useful diplomatic tool. The ICC is the antithesis of a useful diplomatic tool in the case of Syria. So I will end my testimony with those observations, and I look forward to your questions.
Thank you very much, Secretary Rademacher, for that explanation. And again, your full statement will be made a part of the record. I'd like to ask Mr. Dicker if he would proceed.
To the Joint Subcommittee for inviting me to testify. And Mr. Chair, I want to thank you for convening this important hearing. My organization, Human Rights Watch, has conducted extensive research in Syria over the last 2.5 years. We've issued, by my count, 11 in-depth reports documenting horrific human rights crimes. We have conducted 10 in-country field missions to document and support our findings. And my comments today are based on that experience and the experience of reviewing justice mechanisms over the last 20 years. Let me start by saying that criminal prosecutions of the crimes perpetrated in this conflict would present challenges for any court system. And certainly, as has been remarked, justice is not a panacea to all the problems that are besetting Syria today. Trials can only be but one part of a larger package, sir, to bring some healing and accountability to the situation. It's therefore essential, I believe, to think strategically in overcoming what are quite steep hurdles. And this requires, I believe, making use of a range of judicial and non-judicial tools at both the international and national level in a mutually reinforcing spiral that avoids pitting one against the other. Given the exigencies that we see, we believe a three-pronged approach sequenced in time offers the best possibilities for justice, and I will walk through those. But I want to say, with respect, Mr. Chairman, I do take some exception to a single-minded focus on an ad hoc tribunal. Normally, in these type situations, the starting point would be with the national courts and strengthening those as the first line of protection for civilians at risk. I think we all know at this table and in this room that in the near term, any reliance on Syrian courts, even post-conflict, is unrealistic. And while strengthening a revitalized Syrian judiciary is an essential goal, it's a long-term one. My point here, sir, is that the need for credible national justice is clear, but the path to achieving it, frankly, is a long one. I think, given that, we want to draw your attention to the need for the establishment of a specialized judicial mechanism embedded in a reconstituted Syrian justice system with the active participation of international experts. We believe over time that could work to strengthen domestic capacity. And, sir, I would suggest the War Crimes Chamber in the State Court of Bosnia offers important lessons in this regard. This will not be easy in Syria, but if done correctly, it would help build a bridge to the ordinary Syrian courts through joint training and experience sharing to bolster the capacity there. Now, on this difficult terrain, we believe the International Criminal Court has a crucial role to play in prosecuting those most responsible and being a reference point for the special mechanism and evolving national courts already mentioned. The ICC would look at all sides to the conflict and have potential positive spillover effect on future national proceedings, as happened, in fact, in the former Yugoslavia and Rwanda. In spite of that positive impact, I think it's important to acknowledge that given the ICC's daunting mandate, the lack of sufficiently robust state support, and some policy missteps over its first 10 years, there has been a shortfall in ICC practice. Fortunately, the new leadership team at the court, I believe, is cognizant of these problems and attempting to take those challenges in hand. Now, we know that the ICC could only obtain jurisdiction through a Security Council referral. Is it impossible because of Russia's implacable opposition to date to think that such referral could occur? We have seen, as the situation on the ground in Syria has changed, changes in Russia's position on chemical weapons and humanitarian access to populations in need. I argue it would be a major mistake to preclude the possibility of Russian support for a referral. I would also add, unfortunately, the U.S. administration has allowed Russia much more space by failing to itself, from Washington and New York, come out strongly in favor of an ICC referral. In conclusion, I think that the U.S. government's support for an ICC investigation as one mechanism would encourage close allies on the Security Council and raise pressure on the Russian Federation to change its obstructive stance. I believe, with respect, Mr. Chairman, the solution most likely to provide justice is not a standalone tribunal for Syria, because this comes with significant practical obstacles. Reference has been made to the delays in creating and standing up a complex institution from scratch. And I believe that such delay would remove any potential deterrent effect that could be achieved by formally investigating crimes in Syria now. An ad hoc tribunal would be more costly than using an existing mechanism. And at the end of the day, what would its source of legitimacy be, both for the people of Syria and internationally? We recommend, in conclusion, that the administration continue supporting documentation efforts, including the preservation of evidence. This could be vital to future prosecutions. We believe the administration should consider the kind of Sarajevo-type chamber as playing an essential role, and that the U.S. should stand up and support an ICC referral instead of demurring behind concerns that Russia or China would veto any Security Council referral. And we think, lastly, strategy should be formulated with a specialized mechanism and ICC investigation very much in mind. Thank you very much, Mr.
Thank you very much, Mr. Decker, for your testimony. Chairman, would you like to? Chairman Chabot, I think.
Thank you, Mr. Chairman. I do have a flight to catch, so I'll try to be relatively brief. Just a couple of questions. This week, international news sources have been highlighting President Assad's forces laying siege to suburbs near Damascus and the resulting starvation of women and children. How do you determine how far up and how far down you go? For example, the soldiers say at the checkpoints that are blocking people from coming, do they go to the court? Who do you, and I'll just ask one of you if you want to take that on. How's that determination made?
Well, thank you for that question, Mr. Chairman. I think it goes to really the challenge that one has when one is trying to seek justice for victims of any atrocity anywhere. It also depends on the mandate and of the court itself. For example, if it was a local Syrian court, then they would be looking at all the perpetrators, and to include the privates, the sergeants, what have you, whatever that particular perpetrator may be. As you go up the various options which I highlighted to this committee, then it just depends on the mandate. The Special Court for Sierra Leone's mandate was to prosecute those who bear the greatest responsibility, those who created the conditions, aided, abetted, and caused these horror stories. So we, in West Africa, did not go after the foot soldier. We went after the leaders, very much like Nuremberg, where we went after the top 23, so to speak. So it varies. Everybody is culpable. The challenge that we have here is we really can't prosecute everyone. It's almost impossible. One is to find out exactly who pulled the triggers, what have you, but it's just politically not sustainable to prosecute all of the individuals who commit these horrific crimes.
Okay. Thank you.
So therefore, justice will be done, but I'm not sure that we would go all the way down to the individual, the private, at that particular time.
Thank you. Mr. Rademacher, let me go to you next. You had made a reference, and just like to kind of maybe put it in the form of a question. The current administration had, in effect, called for Assad to step aside early on, and then Assad uses chemical weapons against his own people, and now we're working with the Russians and with Assad, and you don't hear too much anymore about, well, he's got to go. Now we're working with the guy. What message does that send to other rogue leaders across the globe who do nasty things sometimes to their own people? Sometimes if they do horrific things, maybe they're going to end up getting rewarded for it. Is that a message we don't necessarily want to send, but maybe was sent in this case?
Yes, Chairman Chabot, regrettably, I think the suggestion of your question is correct. It'll be interesting to see how historians look back on this current, the last few months of what happened in Syria and how they explain or interpret the sequence of events. But I worry that the historical judgment will be that President Assad very cleverly decided to use chemical weapons against his civilian population, killed about 1,500 people, and the consequence of that was that he was enabled to remain in power. That he pivoted and he focused the attention of the international community on the existence of his chemical weapons. He volunteered to get rid of them, but as a practical matter, the price of his cooperation in getting rid of those chemical weapons had to be that he would remain in power. I don't think that the Obama administration today would concede that their policy on the question of the outcome they'd like to see in Syria has changed. I suspect they would still say, no, we want to bring about the removal of President Assad and his replacement by a democratic government. But as we and the Russians work with that very government to dismantle these chemical weapons over a long period of time, and you know, you heard my resume, I used to be in charge of chemical weapons dismantlement for the State Department. You know, we're still dismantling our chemical weapons here in the United States. It's phenomenally costly, phenomenally time-consuming, and I don't know what the latest estimates are for Syria, but I would say multiply by 2 or 3, whatever people are saying, because that's, in the real world, that's how long it will take. And so this is a process that will play out over a long period of time, and I do think the de facto change in policy has been disconcerting. I mean, there have been a lot of stories recently about how upset the Saudis are because they thought America was going in one direction, and now it seems to be going in a different direction, both with respect to Syria and also potentially with respect to Iran. And it's really an astonishing turn of events that we've witnessed.
Thank you. Mr. Chairman, if I have time for one more question. Okay, thank you. Maybe I'll address this to the other 2 panel members who I didn't ask yet. So there's been some media attention recently to Syrian snipers targeting pregnant women for sport, apparently. Is there evidence, could you cite previous examples where either a criminal court has been set up and it actually does modify the behavior of people on the ground? You know, if I do this, I may be prosecuted for this, so that people do perhaps not carry out atrocities that they might otherwise have carried out. Is there something you can tell us along those lines, either one or both? Thank you.
Thank you. What comes to mind is first and foremost the handling or recruitment of child soldiers in eastern Congo, Congressman. After the indictment issued or charges issued against a Congolese warlord by the International Criminal Court, our researchers in eastern Congo reported a release of large numbers of child soldiers forcibly recruited, in many instances, into armed militias, precisely because of that charge against one of their own who was now in the dock at the International Criminal Court. That's one example. I want to be careful in not overstating, however, the deterrent effect of justice, because, let's be frank, it's new and it's fragile. But I think part of the value of early 2.5 years after the start of the conflict, but quick action through a referral to the ICC is it will put those most responsible on notice that they could face criminal charges. I think that stigmatization would be very helpful.
Thank you. Mr. White, did you want to add anything to that?
Yes, just real quickly, from my own personal experience, not only as a federal agent, but certainly serving in West Africa, where we had some of the worst atrocities that you could ever imagine occurred. Clearly, accountability will address the impunity issue. If you do not think that you will be held accountable, you will continue to perpetrate these crimes. I know many of the rebels that I personally interviewed, and some of which became insiders, had committed serious atrocities, from determining who was, whether a pregnant lady for fun was, she had a boy or a girl. They would take a $5,000 or 5,000 Leon bet between the two rebels. Is it a boy or is it a girl? I'll bet you 5,000 Leons it's a boy. And they would determine that by taking a machete and slicing open a pregnant woman and taking the unborn child and determining whether or not it was a boy or a girl and then discarding it as a piece of rubbish. I would submit to you that things have changed in Sierra Leone, and holding them accountable, just like we did Charles Taylor, that's the way to do it. Because once they know that they're not above the law, and you do hold them accountable no matter where you are, that's why I support the singularly focused tribunal. You get laser focused on those that are committing the crimes, you hold them accountable, and you tell them that you're not going to be able to do this with impunity anymore. I think we did it. Things are calm in Sierra Leone. I don't kid myself that it won't come back, but that's how you do it. And I know from talking to these rebels personally, they were scared to death of being prosecuted. Once we landed and we showed up and they knew that they were going to be held accountable, things started to change. That's what I submit to you.
Thank you. And I'd like to thank Chairman Smith for offering this legislation. I'd like to commend him for that. And I yield back.
Thank you very much, Chairman Chabot. Just a couple of questions to start off with. Mr. Crane, in looking, and I did read extensively your Syrian Accountability Project, one of the questions that I still have, who else is doing something that might be parallel to what you're doing? Because I know you have many stakeholders and many people who are part of this effort. And I'm wondering, for purposes of prosecution, how legally actionable is the evidence that's currently being collected? You know, as you cite a time and place when people were butchered or mass rape occurred, you know, Dr. White focused extensively on the centrality of the witness. And I remember when we were debating the Yugoslav War Crime Tribunal here, we had, matter of fact, one of the studies, the Shell study, suggested that we were losing in almost like the dew in the early morning as the sun came out. We were actually losing witnesses, forgetfulness. Some were dying. Some were deciding, I've had enough of this, I'm so traumatized. So time is of the essence to benignly capture the witness so that he or she or they can bear witness to the atrocities in a meaningful way. So I'm wondering how much of that information, witness files, are we assembling that potentially could be turned over to prosecutors with all the protections of a witness protection effort underway?
Thank you for the question, Mr. Chairman. First, it's important to note that there are good-hearted people around the world trying to seek justice for the people of Syria, and they're doing it in many important ways. The Syrian Accountability Project is an attempt to take almost terabytes of information that's being gathered by these organizations and be a bridge between that information. Some of it is credible, some of it is not. A lot of it is not. And build a bridge between this information and creating a mechanism, a cornerstone by which a local prosecutor, a regional prosecutor, or an international prosecutor can then build a case-ready case against these individuals who commit war crimes and crimes against humanity. So that is our purpose. It is, to my knowledge, the only effort, but backed by a lot of good people. And I'm honored to be representing all of them, to include students from Syracuse University College of Law who are here today, who are working diligently pro bono also to assist. But again, we're approaching this practically. Again, with Dr. White and myself and many others from around the world, we're looking at these from a practical point of view, not an academic exercise. Can this case be proven? Can we prosecute, regardless of what the form may be? And the answer is yes, it can be done, and it will be done. Justice must happen for the people of Syria. How that characterizes itself goes the panoply from the ICC, a variation of that, all the way down to a local court. Your resolution, I think, is important in that it lists the central item of that resolution, that is justice for the people of Syria. And I applaud this committee and you, Mr. Chairman, for bringing the attention of the American people to this, and that is justice for the people of Syria. But at the end of the day, this case can be tried in an appropriate form so that justice can be done openly and fairly. And the Syrian Accountability Project is just an effort, not the effort, but an effort to assist that prosecutor in that justice mechanism.
Dr. White, did you want to comment?
No, I don't really have anything
Okay.
to contribute.
If I could ask you, Dr. White, then in your comments, your testimony, you really went into great length about how important it is for the prosecutors, for the court, to establish a trust relationship with the victims. You also point out, and I know that from at least witnesses that I've met with, as a matter of fact, I chaired a number of hearings. One of our witnesses brought women with her who had been raped in Bosnia, and that was Bianca Jagger. And when I met with the women, the trauma and the emotional just pain and suffering and agony that they conveyed was just, it was numbing. And then they were then being called upon to be part of a prosecution in the case of at least one of those women. Very, very difficult. And I'm wondering over time, particularly as, God willing, healing sets in with someone who has been so traumatized, to relive it, all the more reason why the sooner the better. Delay is denial because, again, important witnesses who may have been hurt themselves or observed it are less likely to come forward, I think, the longer this clock plays out. Professor Rapkin said that it is out of the question to launch while Assad is in power. I think when we follow that, and I think Secretary Rademacher's point about the disingenuousness of standing up the Yugoslav court, I remember contemporaneously as well. It was like there was a cynical side to that, but there was also many of us who just wanted it to work and to work robustly and to hold the bad actors to account. But in lieu of doing nothing, that was their default. So the question is, if you could really elaborate a little bit further, and anyone who would like to take it, on the importance of the witness, and again, looking at your suggestions, Mr. Crane, you said the domestic option is the preferred option, but of course that has a built-in delay because there's no peace, sustainable peace, as you point out, in order for all of that to happen. And you talked about the third option, a regional court with Arabs trying Arabs, Muslims trying Muslims, and Syrians trying Syrians as a preferred option, rather than the Westerners. Of course, there could be a support capacity there, to help stand this thing up, and as well as financial. But if you could talk about that witness even further, because I don't think that sense of urgency is understood in Europe, the United States, that like the dew on a morning, these witnesses will go away.
Well, you're absolutely right, and that's why in my written testimony I strongly encourage this. I know there's a lot of debate as to how this should be set up, whether it's the ICC, should it be a separate standalone, should it be domestic. I would just make the point today that whatever forum is pursued, it must be done immediately because these witnesses will dry up, not only for fear of being harmed, but some will be killed. And also if they don't feel that you are there. And this is why it took us months and almost years to be able to extract the trust in the witnesses. And if you're not there, they're not going to come forward because they have to be fearful that they will lose their life and life of other family members. So the sense of urgency, if you do want to collect the evidence, which I mentioned is principally witness testimony, it needs to be done in a very short order.
I would support that statement. That is one of the reasons why this international effort, the Syrian Accountability Project, is putting in place on the shelf quickly so that when it's time, when it makes sense, we can move forward quickly. In any criminal situation, you do have to preserve evidence. You may need to make sure that witnesses are protected and that witnesses are alive for the future court. So I think that it's important for this committee to understand. That's why we have the Syrian Accountability Project and the Chautauqua Blueprint, copies of which this committee has, which is a statutory framework to create any options that we've been talking about this afternoon, to include the contemplation that perhaps the ICC prosecuting those who bear the greatest responsibility, but the statute itself also contemplates the prosecution of the next 100. So there's a combination there, but I can assure you appropriate expediency is in the back of our mind. We want to have this. It's never been done before quite like this. We usually wait, then we react, then we decide. What we're trying to do here is to have something in place so that when the appropriate political solution is finished, then the international community, the local and regional groups are ready to, in fact, put in place an appropriate justice mechanism.
Well, I think all of us are greatly indebted to the work that you're doing to get this in place so we don't wait till after the fact. And so thank you. And of course, all of you are bringing your extensive experience to bear on trying to find solutions, and this subcommittees deeply appreciate that. One of the things that Professor Rapkin said that I was hoping to ask him about was that the work of the tribunals is not well received. I was in Vukovar a month before it fell with Congressman Frank Wolf, and the Vukovar Three were eventually held to account at the tribunal. The atrocities that were committed were horrible. Well, I, along with Mr. Wolf, have met with a number of people who were victims, and they couldn't have been happier with the outcome that finally somebody was held to account. And the same goes for Mladic and certainly Milosevic, who died. I mean, it seems to me that the snapshot of, well, somebody might be unhappy. Well, the news media that was pro-government and pro-Serbia and pro-Milosevic might not be happy. And the disinformation and the propaganda, you know, it takes a while to wean people away from that. But, you know, it seems to me that well-received ought to be seen in a larger time frame as well. Because when you hold these people to account, future generations as well as the victims do feel a sense of justice has prevailed. And I wonder if any of you have any comment on that, because I was struck by that. And whether or not David Crane and Dr. White, you experienced that yourselves. I mean, I know that you had a tremendous rapport with the people. I remember talking to you contemporaneously. You went out and held town meetings and talked to people to explain the process, very often at grave risk to your own security, but you did it anyway. And so if it's explained, it seems to me that potential hurdle can be overcome as well. Yes.
Mr. Chairman, if I may start this ball rolling, two thoughts here. One, I think there is a need to push these international and internationalized mechanisms to recognize their responsibility in making what happens in the courtroom accessible to the communities most affected by the crimes. And that's a challenge for all of these institutions, all the more so because they render justice in highly divisive, polarized situations, as you were suggesting. And I think it's important to remember, while we often and should cite the Nuremberg precedent, it wasn't as if those trials the following day seemed to bring the German people to confront the crimes committed in their name. This takes a while for these lessons, for this confronting who did what for what reasons to really seep down. And I think we've got to allow a bit of a time frame and not impose on it snap judgments. I think that's very important.
Yes, Mr. Crane.
I've got two examples of why and how justice for people who are victims of horrors that are almost undescribable in any form, victims of atrocity. When I unsealed the indictment against sitting President Charles Taylor in June of 2003, it created a beginning, a political dialogue, as well as a legal process that at the end of this, over a period of 2 years, even though there was a lot of diplomatic and political angst, it laid a foundation by which the Liberian people could elect for the first time, freely and without fear, a president, a female president, the first female president in the history of Africa, and it allowed Liberia to move forward with that new election. The indictment of Charles Taylor created that political, legal, practical condition by which Liberia possibly may have a new future. That is a specific and direct result of an international tribunal seeking justice. So that indictment created that possibility. But for that indictment, it would not have happened. I also want to underscore, and I've said this probably too many times in this hearing, and I do appreciate this time, but let me just give you a small vignette that brings it home. Yes, I did walk the countryside. In fact, Richard Dicker and I and Al White also walked the countryside together, listening to the people of Sierra Leone tell us what took place. I was in McKinney, the headquarters of the infamous Revolutionary United Front, Bodie Sanko's group, and Samuel Balkery the Mosquito, because he liked to drink the blood of his victims. And I was giving a town hall meeting in a school for the disabled, many of them disabled by the RUF themselves, blinded, maimed, mutilated. And I was, my custom was, I stood in the middle of the group as opposed to at a high table. I wanted to let them know that I'm listening to them at their level. And a young man stood up. He was deafened by the RUF intentionally, and he was also maimed. He looked me dead in the eye and he said, "I killed people. I'm sorry. I didn't mean it," and he fell into my arms weeping. And as he wept, I looked over and another young woman stood up, about 20 years old, holding her child. She was missing a vast portion of her face, and through cracked lips, clearly looked me in the eye as well, her only remaining eye, and said, "Seek justice for us." So this is why we do this. Regardless of comments by individuals, this is why we do it. It's for the victims. It's for the voiceless who cannot speak for themselves. So this is an honorable thing to do, and modern international criminal law is not perfect. It's 2 steps forward, 1 step back, but it needs to be supported in whatever capacity it is, so the voiceless currently in Syria can have some sense that life can go on under the rule of law.
Yes, Dr. White.
I just want to add one quick comment. I think right now we could build on the recent example of Charles Taylor as a former sitting head of state with his conviction in April of 2012 and his recent appeals that was upheld, 11 counts and a 50-year conviction. Right now we have credibility that we can bring people to justice and hold them accountable. And just one quick story that I will not forget, as David pointed out, we were out in the countryside, not only in Sierra Leone, but Liberia. And when Charles Taylor left Liberia on August 11, 2003, he looked the people in the eye and said, "God willing, I'll be back." That sent the shiver down the spine of people not only in Liberia, but Sierra Leone. And they were fearful he was never coming back. And my witnesses repeatedly would call me and say, "Doc, Pape cannot come back." I said, "I promise you, Pape will not be coming back." And when we were at The Hague, during his recent appeals verdict was read, we were in the chambers. I had a number of witnesses call me from Sierra Leone and Liberia. And for the first time in their life, at least in modern time, the last 10 to 15 years, they could breathe a sigh of relief because they said, "Doc, you said he's not coming back. Now I can go to sleep tonight because I know he's not coming back." That's about as powerful as you can get, that you know you can't get everybody, but you need to hold these people accountable, and it needs to happen quickly. We've learned a lot of lessons. This doesn't have to take a long time to get done. However it turns out, it needs to get started, and it needs to get started now. Thank you.
So would that add additional merit to Secretary Rademacher's argument that Article 16 of the Rome Statute makes it less likely that a guy like Charles Taylor could, on the interim basis, go to Nigeria and then be apprehended to The Hague under the Sierra Leone Special Court and then prosecuted? Is the ICC that rigid? I mean, one of the additional points, and maybe Secretary Rademacher, you might want to further elaborate on this, and why I believe that the Russians, and I could be wrong, but why I believe the Russians are less likely to obstruct the creation of such a court is that it holds all sides to account. And we know the al-Qaeda operatives and many of the Syrian rebels are doing horrific things. And, you know, when you're getting tortured, you don't say, hey, are you a leftist or a rightist or anybody in between? You know that it hurts and sadly often leads to your demise. So does that lend credibility to why the ICC might not be the suitable means for this to go forward?
I think the answer to that question is yes. We've talked about a number of historical situations here. I think a key distinction between the situation in Syria today and for example, the one in Sierra Leone when you gentlemen began your work was Charles Taylor was no longer in power. In Syria, President Assad is still in power. And that creates a fundamentally different dynamic. And if the desire is to bring him and perpetrators of gross violations of human rights under him to justice, it is a much more challenging situation than if these individuals have already given up power. And I believe that from a purely humanitarian point of view, the number one priority is to persuade them, well, to bring about a change so that they leave power and are replaced by hopefully more democratic, more tolerant officials. And that to me has to be the primary objective, and we're going to achieve that through the use of diplomatic tools. And so I think the first question is, of the various options that we're looking at, how effective would they be as diplomatic tools? All the options suffer from some of the same problems. Most of them that we've talked about would require Security Council approval, or they would require a change in government so that the domestic judicial system could function, for example. But as we look at those tools and evaluate their potential usefulness diplomatically, I submit that the most useful one diplomatically for bringing about a political transition in Syria is the ad hoc tribunal. The potential use of the International Criminal Court will backfire as a diplomatic tool. It will guarantee, and I mean that literally, it will guarantee that Assad will not leave peacefully, because you can imagine the conversation. Diplomats go to him and say, we think it's time for you to go. Will you please leave? And his first question will be, what will become of me once I leave? You've sicked the International Criminal Court on me. Can you make that go away? And I know what the answer to that question is. The answer to that question will be, we can make it go away for 1 year. The Security Council will adopt a resolution. We guarantee you, the Security Council will adopt a resolution that defers the investigation of your case by the International Criminal Court for 1 year. And you can imagine President Assad's follow-up question will be, well, that's very, very good. What will happen at the end of that year? I'm interested because we're talking about my life and my freedom. And the answer is, well, I mean, if we're leaning far forward, the answer will be, well, we guarantee to use our best efforts a year from now to persuade a majority of the members of the Security Council, including all 5 of the permanent members, to extend that deferral by another year. And he will say, can you guarantee that they will extend that deferral for another year? And the answer will be, well, no, we can't guarantee that, but we promise to work really hard to try and achieve that. And then he'll say, and what happens a year later? You're going to work really hard a year later. He would have to be really stupid to buy the notion that he's going to escape International Criminal Court prosecution, that for the rest of his life, once a year, the United Nations Security Council is going to adopt a resolution deferring by yet another year the ICC prosecution of his case. And you can imagine all kinds of problems. at one point, one permanent member can object, and that's it. A veto would restore ICC jurisdiction. So someone in his case will never buy the notion that the ICC can be called off. And that, to me, is a fatal flaw in the design of the Rome Statute and of the International Criminal Court. It makes the International Criminal Court the most useful, the most dangerous tool, the most counterproductive tool we could possibly deploy in the current situation. An ad hoc tribunal could be constructed differently. It's not subject to Article 16 of the Rome Statute. And so it could be designed such that as part of a diplomatic settlement where Assad agrees to give up and retire peacefully, the case is withdrawn, the prosecutor is stood down. I submit that ending the civil war in Syria is more important than sending the people who've committed horrible war crimes up until now to jail, especially when we understand that no international institution, no international mechanism is ever going to hold more than 100 or 200 of these individuals accountable. The vast majority will either escape justice. The vast majority of people who've committed these kinds of offenses in Syria will either escape justice entirely, or if they are held accountable, it will be through the courts of Syria under a different government. Because in the Yugoslavia Tribunal has handled fewer than 200 cases, the Rwanda Tribunal fewer than 100. 800,000 people died in Rwanda. And most of them died because they were hacked to death by people wielding machetes. I mean, I can assure you that more than 100 people were wielding machetes to kill 800,000 people in Rwanda. But the Rwanda Tribunal, because of capacity constraints, has only been able to look at fewer than 100 cases. So, it's a frustrating situation, but the answer the Europeans are going to give us on this problem is it's got to be the ICC. And I think that is a prescription for prolonging the conflict in Syria, which would be a disastrous. It's a cure that would be far worse than the disease.
I'd like to yield. Oh, okay. I'm sorry.
Because I think Secretary Rademacher put some very important issues on the table that really do need to be addressed. The interface, if you will, between justice and peace. The imperative behind this hearing is trying to bring some redress for those who have suffered horrifically in Syria. I think we make a misstep if reflexively we pit justice and peace against one another. Certainly we want both. We want an end to the killing and bloodshed in Syria. There's no question of that. I think it's how we manage those two objectives and manage them smartly without throwing justice under the bus. And I believe that it can be done. I think a good example of that, two good examples, though one with individuals in power, was the Dayton negotiations, wherein Slobodan Milosevic attended, Radovan Karadzic, Ratko Mladic did not attend because, as you know, they were indictees. That peace negotiation went forward. And the second example to cite is the one that David Crane is most familiar with, the talks on Charles Taylor's departure from power that were taking place in Accra when the prosecutor unsealed his arrest warrant or indictment against Charles Taylor. I think it's possible to manage these two carefully, smartly, not just throw one against the other. So I would take some exception, of course, to what Secretary Rademacher said. Lastly, I would fear for any tribunal that had indicted Bashar al-Assad to withdraw the indictment because a peace settlement had been achieved. Let's go back to the victims in Aleppo or Dara. What will be the response and the confidence in justice if, as a result of a political settlement, a prosecutor says, hey, forget it, here's your get-out-of-jail-free card. I think we can do better than that. Thank you.
Mr. Conley.
Thank you, Mr. Chairman, and thank you for holding this hearing. Fascinating discussion. I guess I want to pick up on what Secretary Rademacher was getting at, which I think is efficacy. And efficacy is, of course, determined by the goal. If the goal is defined as let's end the bloodshed in Syria, then it seems to me that Secretary Rademacher has a point that even if we have to hold our nose with respect to the status of Bashar al-Assad, the greater good is served by the ending of bloodshed and the succession of a government that tries to be inclusive. The problem with that is it avoids closure, which Dr. White and Dr. Crane were both, or Professor Crane were both talking about, how important that was in your own experience, both in Sierra Leone and in Liberia. We have models of closure. Some are violent. The Ceausescus were apprehended fleeing Romania and were summarily executed. Gaddafi was captured and summarily executed. Saddam Hussein was captured by U.S. troops, interrogated, handed over to the Iraqi authorities, I guess tried and executed in a process, however we might view such a process. All of those examples do not escape the attention of Mr. Assad, presumably. And it seems to me the choice for him is at least, he has three options he's got to look at. One is the Gaddafi choice, in terms of how it ends. And if that's what you fear, if that's what you really think is the threat you face, then you double down on your military option to try to avoid that fate. If you think that there's another option, that you're facing unpalatable options, then maybe either the ICC or an ad hoc tribunal is a better option, because at least you continue to breathe. The third, which you suggest, Secretary Rademacher, which I think unlikely, but it could happen, is you get a get-out-of-jail card pass through the Security Council or some mechanism similar to that. If those are your three options, Secretary Rademacher, at some point, if there's a deterioration in the military situation in Syria, doesn't Assad have to look at one of those three options, even though none of them are very palatable?
Well, I think there was a very important if embedded there in the questions you just asked. I think today, President Assad's looking at a fourth option. He's looking at fighting and winning.
Right.
And if he starts to lose and it becomes evident that he will lose.
Excuse me, I predicated my question with if the situation deteriorates militarily.
Right. Okay, well, and I'm pointing out that that's a hypothetical situation because
I understand.
by all accounts today, the military balance is sort of tipped in his direction. And, I don't think Gaddafi's plan initially was to be hunted down, killed in the street. I think he thought he could fight to the end and he believed prevail. And I think there's no reason today for President Assad to think that he's losing. I think there's a lot of evidence that suggests at the moment he's doing just fine. And so, we can all pick our analogies here, but let me throw one out. Yes, these are unpalatable choices, and letting justice go unrequited is unpalatable, especially to the victims. But these kinds of choices get made every day, including in our own legal system. And plea bargaining, I'm sure we have some former prosecutors here in the room. I mean, plea bargains happen in our system all the time. Sometimes for purely legal reasons, sometimes for other reasons. I noticed in the news this morning, the protests in Israel today because Prime Minister Netanyahu is releasing, I think, 40 Palestinians convicted of horrific crimes against Israelis. Why is he releasing these people, long before their criminal sentences have been served? Well, I think the reason he's releasing them is because Secretary of State John Kerry broke his arm to release them, because he wants to energize the peace process and get the Palestinians engaged in negotiations with Israel. That was the judgment of the Obama administration, to strongly lean on the government of Israel to release terrorists, convicted terrorists, from Israeli prison, because that would yield a benefit, they believed, in a diplomatic process that they think is very important. And Netanyahu capitulated in the face of that pressure from the Obama administration. Now, was the Obama administration wrong? Was Netanyahu wrong? I think if you adhere to the line that Mr. Dicker just put forward, yes, they were wrong. Because there are victims protesting in Israel today that the perpetrators of horrific crimes against their family members are being let go. But the policy of the United States is to favor that, because we see more important issues at stake. Now, so that's the analogy I put forward for us to think about it. Don't condemn my idea unless you're prepared to condemn what Secretary Kerry has foisted on Prime Minister Netanyahu.
Yeah, I don't think anyone was condemning your idea. I think we were trying to explore it. Okay. Professor Crane, Dr. White, what about that? You were making the case that, rather forcefully, that there's a real deterrent effect just with the threat of prosecution, and even more strongly so once, in fact, the indictment is handed down. Secretary Rademacher suggests the opposite, that actually it could force Assad to figure he has no other escape route other than doubling down on the military situation and actually perpetrating even more violence and crime against humanity in Syria. What about that? That it could have the unintended effect of actually worsening a situation rather than the deterrent effect you described? And let's stick to Assad and Syria for a minute.
Certainly. These aren't cookie-cutter approaches and concepts that we're offering this committee. The Secretary is correct in that there has to be a political as well as a judicial as well as a diplomatic mechanism by which the horror that's going on in Syria ends. We had a civil war going on in Liberia when I unsealed the indictment and Charles Taylor is removed. The political solution at the time, even though we were ready to actually receive him to prosecute him, was to move him off into another location for a couple of years. I can see potentially, and it's just a potential, that happened, that he be removed, he agreed to leave, and that he be removed, and a diplomatic and political solution for Syria happens. But over time, perhaps a legal solution is also worked out, and that's what happened with Charles Taylor. He was handed over, but it's a political decision. The bright red thread of all of this, Congressman Connolly, and by the way, you used to be my congressman in Northern Virginia. I moved to North Carolina. My apologies, but
Lord Almighty.
But the bottom line, the bright red thread of all of this is politics. We have the procedure, the jurisprudence, the experience to prosecute Assad and anybody else that commits these atrocities. But it won't be a legal decision that happens related to however this manifests itself, which could be anything in between. It will be a political decision to end this.
Professor Crane, if I may, and I want to hear Dr. White's response as well. But Secretary Rademacher makes a point that has to be addressed. But what if, despite the best of intentions and the need for closure from victims, by taking this action, we worsen the situation and we actually have him dig in his heels, especially in a situation where, as the Secretary points out, militarily he seems at the moment to actually be on the upswing?
Well, one is that I'm not advocating that we have a court now, create court, indict the individual either through the ICC, what have you. I think we have to have a political solution, a ceasefire, and a stabilization of the situation. I think that's important. But there also has to be justice. It's a peace and justice.
But what's his motivation to do that if he's prevailing on the battlefield and he knows what awaits him from a ceasefire and a negotiated settlement is, prosecution in some kind of international court of justice, whether ad hoc or the ICC, and an unpleasant fate upon conviction?
Well, that's a great question, because the bottom line is that very well could happen. There are several scenarios, from a peaceful settlement all the way to what I call the Armageddon scenario, where he goes down like Hitler, he'll just put Syria in flames and everything in between. We might wake up tomorrow morning, Congressman, and find out that he's in Russia or Iran. He's quietly left. That's another scenario. This is kaleidoscopic. The what-ifs can certainly be argued against any kind of justice. At the end of the day, there's going to have to be some justice, whether it's Assad or his henchmen or those who perpetrate the crimes. At the end of the day, the international community may say, well, it won't be Assad, at least for now. It may be others. It's going to be, at the end of the day, not a legal one, but a political one. And I'm certainly not advocating that we start a justice process now. I do think there has to be, whatever that may be, a type of political settlement. But what we're doing is just, should the decision be made that justice be done, in whatever capacity that is, greatest responsibility, everybody else, then we have that capability. I know I didn't answer your question because I don't really have an answer, to be honest with you.
Dr. White?
Certainly there will be some political input to this, but I think, and each one of them will be case by case, but I would still argue, as a former federal agent, that we never ran away from justice. And plea bargains, as he rightly states, comes in many different forms. But had we not indicted Charles Taylor and unsealed it, he would not have left, okay? And look, we've got al-Bashir, we have all these other people. That's where we have a credibility issue right now. And I'll just be candid. That's one of the issues facing the ICC right now, is not bringing people like this to justice. At least if it's singularly targeted, singularly focused, and you're dealing with the victims. Up there, you're in The Hague, you're not really talking to the people, so the victims get lost. But there's two other things you can do. I think justice still needs to be pursued. I can tell you right now, many people wanted us to drop the indictment of Charles Taylor, and this man held firm, okay? We just did not cave into that. We did the right thing for the people, and it all worked out. But there's another process that we can go through for the victims, and we had it in Sierra Leone, and they had it in South Africa. And that was the Truth and Reconciliation Commission. It's not perfect, but it does allow the victims to come forward, face their perpetrators, and have their day in a public court, which is another mechanism when these atrocities occur. So you have retributive justice and restorative justice. So those are the two mechanisms that need to be thought through. And they are very different. They're very complex. But you can't let these people escape justice for just the fear of not being, okay, if I agree to this, I'm not going to get prosecuted. That should be after the fact. That should be part of any sentence or any, perhaps in the process along the way, taken into consideration. But I would never remove the vehicle of justice along the way. So restorative and retributive justice are the keys.
Secretary Rademacher, you look like you want to respond.
Not so much a response as just an additional point that I think might be useful for everyone. Dr. White just referred to the situation in Sudan, where President al-Bashir is under ICC indictment. He's been indicted since, I think, 2008, so he was indicted 5 years ago for the first time. He was indicted on a second count in 2010, so he's been indicted twice. And I would submit that one of the reasons he's still there is because of the ICC indictment, that he, like Gaddafi, like potentially President Assad in Syria, if he were to be indicted by the ICC, he's been denied the option of a graceful exit, which is the option that President Mubarak was able to avail himself of in Egypt, and the former President Ben Ali of Tunisia, he was able to go into exile. But
Idi Amin.
Idi Amin, still living in Saudi Arabia. But what I wanted to do was read two quotes, which I think are informative, because with the Darfur crisis, we've had a series of special United States envoys whose job it has been to solve the Darfur crisis and hopefully bring about a political transition in Khartoum and the replacement of the al-Bashir government. And so in the Bush administration, one of those special envoys was Andrew Natsios, former AID administrator. At the time of the first ICC indictment of President al-Bashir, Andrew Natsios said the following: "The regime will now avoid any compromise or anything that would weaken their already weakened position, because if they are forced from office, they face trials before the ICC." So that was after the first indictment. 2 years later, we'd had a change in administration. We had a new special envoy, Scott Gratian, President Obama's special envoy. At the time of the second indictment, Scott Gratian said the following about the ICC action, that it will, and I'm quoting, "will make my mission more difficult and challenging." I mean, these are the diplomats vested with responsibility by the President of the United States to try and solve, through diplomatic means, the Darfur crisis. One's a Republican, one's a Democrat. They agree on one thing: the ICC and its criminal indictment of a sitting president in Khartoum with whom they were supposed to be negotiating to solve a humanitarian crisis. The ICC action made their work much more difficult, if not impossible. And I would submit that to the extent anyone in Europe or elsewhere, or at Human Rights Watch, wants to encourage us to bring in the International Criminal Court, they ought to listen to what some of the diplomats who experienced a similar move in a similar crisis a few years ago had to say about the upshot of ICC involvement.
And finally, Mr. Decker, and then, Mr. Chairman, I'm done. Thank you so much.
Well, again, these are such fundamental points and so important to exchange ideas on. And Congressman, I thank you for focusing on this theme. I would say, one, we are at the start or early stages of a new era, if you will, and that is the potential liability of sitting heads of state or other senior officials for mass slaughter of civilians, the use of rape as a weapon of war, forced displacement of populations, etc. So this is a new development, and I think the Secretary is absolutely accurate in his comment that, yes, it makes the work of diplomats more difficult. There's no question about that. But as law evolves, the challenges become greater for not only diplomats but office holders. And I think that's a positive thing, because it's a better world where genocide is proscribed as a criminal act. Point one, I think, again, we need to manage these tensions, and the Secretary has underscored the tensions, and they can exist, but we need to manage these tensions smartly. And my own reflections on the Darfur situation was, when the arrest warrant was issued in 2009, there was quite a backlash that it would collapse the comprehensive peace accord in Sudan, that Bashir would pull out. No such thing happened. I think we've got to be more thoughtful and careful thinking, and not just projecting reflexively, if you will, the worst case scenario, though certainly I think we do need to take it into account, but really work our way around it. And I think that's essential, not only to the furtherance of law, but to the needs and aspirations of victims. Thank you.
I would just say, in conclusion, I think all of you have made great points, and one is torn. I referred to the word I began with, which is efficacy. What is it we are seeking to accomplish? We have to, it seems to me, be on our guard about only making a point, even a moral point. Not that it's invalid, but while people are being killed, that's an indulgence I'm not sure they can afford. Maybe we can. And the removal of Assad presumably is part of our goal. Who replaces him is a very problematic question. So as we use this tool, hopefully judiciously, I think Secretary Rademacher's caution is well taken, which is we must be careful that it not be counterproductive despite our good intentions, and the result being that we actually inflict even more harm on the people of Syria. So we don't face easy choices here with this tool. We have examples where it worked. We also have examples where it led, well, in Sudan, someone indicted not once but twice is still very much in power, entrenched, and arguably, according to our own diplomats, because we employed the tool, perhaps prematurely, perhaps too crudely, perhaps because it's too rigid, I don't know. But at least so far, the story of Sudan counters our good experience in Liberia. It didn't work. So what will work in Syria, and what is it we wish to achieve? Bringing Assad to justice as the only goal is obviously not satisfying. It can't be our only goal. I wish it were that simple. And so working through this thicket is going to be no easy task. But thank you all very much for your thoughts. Very, very enlightening. Thank you, Mr. Chairman, for holding this hearing.
Thank you very much, Mr. Connolly. I just have one or two final questions, and you've been very generous with your time, and we deeply appreciate it. Mr. Crane, in your testimony, you pointed out that the ICC has a track record over the first decade that it's spotty, it's questionable, it lacks the capacity and political and diplomatic sophistication to handle such a mandate, coupled with the challenge of gaining jurisdiction over the atrocities. The reality is that the ICC is just not up to the task. It can barely handle the current caseload and investigations. You also point out, and I would just note parenthetically, Greg Simpkins and I, between September 22nd to the 24th, were in Jos in Nigeria, and observing firsthand the atrocities committed by the Boko Haram. And we were advised, I had not known that before I went there, that the ICC is looking into possibility of indicting or initiating investigations into some of the Boko Haram individuals, but they're talking about just less than the number of fingers on my right hand, and that was in July, and nothing's happened yet. Time is going on. I would also note parenthetically as well that unless the website has been updated, there were 18 prosecutions, 1 conviction of an individual in the Democratic Republic of Congo. Yes, a number of indictments that are very significant, but very, very high-level people like Presidents Bashir and others, Joseph Kony, but very little in terms of anything to show for it. And I would also note that you make a point, and I think it's an excellent point, about Arabs trying Arabs, Muslims trying Muslims, Syrians trying Syrians as a preferred option. The effort could or would be supported, they're talking about the regional court, by the Arab League and Arab jurists supplemented by Syrian jurists. If you look at the ICC list of judges, it's Kenya, France, Philippines, Mali, Nigeria, Argentina, Czech Republic, Dominican Republic, Germany, Finland, Botswana, United Kingdom, Japan, South Korea, Brazil, Italy, Bulgaria, Latvia, and Belgium. I don't see any Arabs among the lists of judges, making those who would sit less likely potentially to be acceptable. So I wonder if you just might want to touch on that. Again, this capacity idea. Mr. Dickert points out that there could be delays in costs with an ad hoc or presumably with a regional as well. But it seems to me that the costs, if there's a will, far outweigh the ongoing humanitarian debacle and crisis we're facing with all of those IDPs and refugees, not to mention the horrific spilling of blood. So if money is an object, I mean, that would be absurd, in my opinion. Delays, I mean, we've learned from the special court, from the ad hocs, if we can't apply quickly a lessons learned, shame on us. But it seems to be there's a lack of political will. By default, I would respectfully submit the UN Commission on Inquiry in Syria, and its February 2013 says, yes, go with the ICC. But I think there is a better option, and I know you, and I deeply respect your view, disagree. But again, Mr. Crane, if you could speak to that issue. I mean, look at those judges. None of them are Arabs. And again, you did talk about the lack of capability on the part of the ICC.
Well, I think just to address the immediate question about Arab judges. Unfortunately, even though we have, I believe, 125 nations who have subscribed to the Rome Statute, very few, if at all, that I recall. Richard, you can correct me, but I don't know of any Arab state that actually has signed on to the Rome Statute. It's a vast blank in the world related to the Rome paradigm. Be that as it may, then a judge, an Arab judge, to put it euphemistically, would not necessarily be on that. Not just like you wouldn't see an American or a Russian or a Chinese judge on the ICC, is because they're not members of the state's party. And the Rome Statute contemplates that you must be a member of the state party that signed on to the Rome Statute to be in those capacities. So that's still problematic in the sense of we don't have the important cultural gifts that the Muslim world, the Islamic world, brings to any table, and that would be problematic should the ICC have this referred to them. In the general sense, that is my statement. I stand by that statement. I am a disappointed and concerned supporter of the ICC. I've seen it begin. I've worked with it. I want to see it succeed, and they have their challenges. And so I am also a pragmatist, because, again, I don't look at it as the ICC or a hybrid or an ad hoc. I go back to what I've said throughout this afternoon and on the record for years. It's for and about the victims. And whatever mechanism that allows justice for the victims of any atrocity, then I'm for that, whatever you want to call it, frankly. So the ICC exists. It is part of a major international scheme signed on to by 125 countries. It's there. So my point is that we have to support that concept, try to make it better, try to make it more efficient, seek justice for victims of atrocity in other ways as well. It is not the default. In fact, we tend to forget this at this table and elsewhere. The ICC is a court of last resort. It was never designed to be always in the front row, always leading something. And I think that they've made a mistake about that, and that's my concern. That's really, they're always looking for something to be involved in. In reality, they should be waiting for something to be referred to them that's appropriate. The gravest of crimes. The principle of complementarity is important. States parties should prosecute their own, or other parties. And we should be working on building the capacity of nations to prosecute their own, and that's why I think honestly and with merit that a Syrian type of court, internationalized or a pure domestic, in my mind, bolsters the idea of the principle of complementarity. Let those who have been victims use their justice mechanism and criminal system to seek justice, or if they can't or unwilling or unable, then it be referred to the appropriate court, such as the International Criminal Court.
Comments? If you could, maybe for the record, because I'm sure maybe you have it readily at your hands, what the possible cost would be of a regional court or an ad hoc court? Do you have any sense of what the order of magnitude and cost it would be?
Well, let's just look at it anecdotally.
Sure.
The Special Court for Sierra Leone, in general, costs $25 to $30 million a year. At first, when Dr. White and I first stepped off the airplane with 3 suitcases and our political assistant, which was the Special Court for Sierra Leone, on 7 August of 2002, we were pretty cheap, but that first year was about $10 million. So we were averaging, give or take, $35 million. It's my understanding that the ad hoc tribunals cost on the average of $150 million each per year, and you can multiply that by essentially 20 years, and you can see the cost of that. The International Criminal Court's budget, Richard, correct me if I'm wrong, but I believe it's around $150 million a year. So that's just a general balance of what these would cost just based on what the previous courts cost.
Any final words? If not, I would like...
If I may, Mr. Chairman, just to say, I think that we are strong supporters of the International Court. We're not apologists for it either. And by that I mean, certainly there have been problems. I think the court needs more political and diplomatic support, and it certainly will need that in handling a Syria referral. I think it's part of the evolving international justice system, and looking down the road, unfortunately, with a simple standalone ad hoc tribunal, you're not likely, in the way that one would hope, to maximally strengthen what is a new and albeit fledgling, struggling system. And I would say, sir, that I think that's argument for this government in supporting the emergence of this system.
With respect, one of the takeaways that I had from the Sierra Leone court was it left physical plant structures, prosecutors who knew, investigators who learned from the best of the best, and with a country coming out of the terrible agony that Syria will have to emerge from, seems to me leaving behind, through a regional court or an ad hoc tribunal, that kind of capacity, is far to be preferred to an ICC action that would occur at The Hague and would be largely separate from a domestic capacity consequence, leaving behind. Am I right on that?
Well, certainly the advantages of the hybrid international tribunal in Sierra Leone, the Special Court for Sierra Leone, did allow us to be present at the location. It is the challenge of the various other tribunals. They're not at this crime scene. So certainly the innate training that goes with incorporating local prosecutors and investigators and police and what have you goes along with that. So yes, there clearly is a legacy left at many levels, the ability of the people of West Africa, and specifically Sierra Leone, to have the capacity to manage complex investigations and cases. It's there. It's obvious. If you have a court at the crime scene, like Nuremberg, like Special Court for Sierra Leone, the people see that justice, and of course the legacy aspect of it is obvious.
Thank you so very much, gentlemen, for your extraordinary testimony, and it is of supreme assistance to this committee, and we will proceed forward with this, and I thank you for it.